Hello guys, welcome to my channel. The less is more. So today we will discuss explain page of Indian Express, and the topic today is prisons. And let's see the title itself. Model Prisons Act 2023. How it differs from existing laws, why its need was felt. Okay. The Ministry of Home Affairs said earlier this month that it has prepared a Model Prison Act. So, Ministry of Home Affairs has prepared Model Prison Act 2023 to replace the existing 130-year-old colonial law governing prisons. So, the previous law was almost 130 years old. The new act seeks to bring in the use of technology in prison management. So what's new in this law? That is use of technology in prison management, regulate payroll, furlough and remission, and introduce special provisions for women and transgender inmates. So this is the three things that is those are new in this law. Okay, that first is use of technology, then regulate payroll, furlough and remission, introduce special provision for women and transgender. Why was the need felt? Announced on May 12, the Model Prison Act 2023 is being introduced following the spate of killings and gang violence within prisons. The reason for this Model Prison Act is spate of killings and gang violence, such as the recent murder of Tillu Tajpuria inside Tihar jail. So you can give this example of Tillu Tajpuria in Tihar jail. Also, Home Minister Amit Shah, speaking at the inauguration of 6th All India Prison Duty Meet 2022 in Ahmedabad, had announced that changes in the prison law were in the works, while calling for a rehabilitative view of prisoners and jails. So, in 6th All India Prison Duty Meet in Ahmedabad, Amit Shah had announced that changes in the prison law were in the works, while calling for a rehabilitative view of prisoners and jails. So, the government is now approaching towards a rehabilitative view, which kind of retributive justice. Rehabilitative view, retributive justice. Okay. Shah had said that India's incarceration system was prone to abuse as it was set up by the British to subjugate political prisoners. So, the earlier or the British prisoners that were built during British era was to subjugate political prisoners. Okay, so that's why it was prone to abuse. In a similar vein, the MHS statement from May 12 said that the Pre-Independence Prison Act 1894 focused on keeping criminals in custody and enforcing discipline and order in prisons, leaving no provision for reform and rehabilitation of prisoners. So, the older act, that is Prisons Act 1894, was focused on keeping criminals in custody and enforcing discipline and order in prisons. That's why leaving no provision for reform and rehabilitation. What are the new provisions being proposed? The Model Prison Act seeks to create provision for the grant of payroll, furlough and remission to prisoners to encourage good conduct. Also, it aims to provide separate accommodation to women, transgender, ensure the physical and mental well-being of prisoners, and focus on the reformation and rehabilitation of inmates. So, the new provisions, as we have discussed in the introduction, women, transgender, physical and mental well-being of prisoners, reformation and rehabilitation of inmates. It seeks to bring about transparency in prison management and includes provision for security assessment and segregation of prisoners, individual sentence planning, grievance redressal, a prison development board, use of technology in prison administration, protecting society from criminal activities of hardened criminals and habitual offenders. So these are the all provisions that are being proposed in the new model act. The first is transparency in prison management, security assessment, segregation of prisoners, individual sentence planning, grievance redressal, prison development board, use of technology, and protecting society from criminal activities of hardened criminals and habitual offenders. Provisions for establishing high security jails and open, semi-open jails have also been inserted. So there will be three types of jail: high security jails, open and semi-open jails have also been inserted. Apart from this, new measures for prisoners to video conference with courts have also been introduced. So video conference with courts, this is the new provision that has been introduced. However, if a prisoner is using prohibited items like mobile phones in jail, they will be punished. Along with the Prisons Act 1894, the Prisoners Act 1900 and the Transfer of Prisoners Act 1950 have also been reviewed by the MHA, and the relevant provisions have been assimilated into the Model Provision Act. So along with this Provision Act 1894, another act, three acts were reviewed, that is Prisoners Act, Transfer of Prisoners Act 1950, okay, to assimilated into Model Prison Act. What were the earlier laws? The first legislation that governed the management and administration of prisons in India. First legislation that governed management and administration of prisons in India was the Prisons Act of 1894. It defined the prisons as any jail or place used permanently or temporarily under the general or special orders of state government for the detention of prisoners, excluding police custody and subsidiary jails. So this is the definition of jail, that is prison or any jail or place used as what, permanently or temporarily under the general or special orders of state government for what, detention of prisoners, excluding police custody and subsidiary jails. The act had no provision for reformation or rehabilitation and permitted whipping, provided that number of stripes shall not exceed 30, albeit for only male prisoners. Moreover, this act did not apply to civil jails in the state of Bombay, outside the city of Bombay, and those jails administered under the provision of section 1916 of the Bombay Act 1874. So earlier act had no provisions for reformation and rehabilitation and permitted what, whipping, and stripes shall not exceed 30, and this act did not apply to civil jails in the state of Bombay. Thus, the Prisoners Act 1900 was introduced with the objective of consolidating the several acts relating to prisoners and replacing the separate enactment by a single act. So, the Prisoners Act 1900 was replaced by, has replaced the older, that is 1894 Act, for separate enactment by single act and consolidating the several acts relating to prisoners. Expressed more simply and intelligibly, The act dealt with prisoners within the presidency town and those outside. It also included provision on how to deal with lunatic prisoners and allowed prisoners to be removed from prisons upon conditions like receiving death sentences and maintaining good behavior within prisons. At present, the jail manuals of each state deal with administration and management of its prisons. Is the new act binding on states? According to the provision of the Constitution, prisons and persons detained therein fall under the state list. This means that the responsibility of prison management and administration is with the state government, which alone is competent to make appropriate legislative provisions in this regard. However, the MHA stated that owing to the critical role played by efficient prison management in the criminal justice system, the Center finds it crucial to support the states and duties in this regard. While announcing the 2023 Act, the Ministry clarified that it may serve as a guiding document for the states so that they may benefit from its adoption in their jurisdiction. So, guys, we have seen that what was the need for this act, okay, then what are the new provisions that are being proposed, okay, and what were the earlier laws, 1894, 1900, okay, where it was applied, that presidency town. And if the new act is binding on states, then it's just a model act, because the prison management and person detained therein is under the state list, okay. So, and we have also seen the definition of prison, okay, and which kind of new provisions and what kind of new jails will be built, that is high security, open and semi open jails, okay. And what were the earlier laws? Then it's a Prisons Act 1894, then no provisions for reformation and rehabilitation, then this did not apply to civil jails, weeping was allowed in this 1894. Prisoners Act 1900 was introduced with consolidation, okay, and this act was applied in presidency towns, okay. So this was for today. I hope you guys would be understanding. Thank you, bye bye, signing off for the day.